Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to look at an article that's been sent to me by about a half dozen of you going, what's going on with this one? And it's a bit of a headache sort of inducing story, so I've got myself a drink, although I'm going to be going through some fairly dense law, so I've got something a little lighter than a scotch here. But this article is titled, Give My Back Guns, Local Man Tells RCMP, which suggests that the author, I suspect this headline's going to get fixed at some point, but at this point, this is what it says. So I suspect the headline author might have been a little ahead of me on the drinking here. What it probably meant to say is, give my guns back, local man tells RCMP. So what this is about is Michael Rupert has apparently filed a court claim asking for the RCMP to be forced to return his property. I'm going to summarize the article. It's up here. I'll quote parts of it, but I'll link to it as well, just so that you can see it as you need to. So 2 locked safes containing guns, ammunition, etc. were taken by Mounties from his home on August 14th, 2019. That date is important because we're going to have a bit of a timeline here. After officers were called to an incident between him and his then spouse, who I'm guessing is not his now spouse, because, yeah, this does not seem like it's a happy scenario for anyone involved. Firearms were not involved in this incident or in any other incident between the petitioner and his then spouse, which is important because if they were, we'd be looking at a different sort of scenario here. And so initially the Crown sought a peace bond between him and his former spouse, which suggests that they weren't seeking criminal charges. So that tells us something here. If he was never charged, then they're proceeding under the peace bond section instead. So it suggests that there wasn't an assault, that there wasn't an uttering threats. There might have been. I don't know for certain. But usually if those things had happened, they would proceed under those things. So I'm sort of reading between the lines here. I'll also note that this is it might be a statement of claim or some other sort of originating document for a lawsuit. And so this is going to present the case in sort of the best light for him. None of this seems to have been proven in a court at this stage. So I'm just accepting this as, if all of this is true, then how does this impact things? But these claims will ultimately need to be proven. He's going to have a court battle ahead of him to establish all of this. So December 2019, the peace bond is dropped and there's no other charges. Everything is done. So he goes back and says, I want my guns, please. And the RCMP say, no, you can't have them. And he says, why? And they say, well, because back in September 2019, we got an order that says they're forfeited to us. And according to Mr. Rupert, he never got any notice of this. So this was a surprise to him, which is a thing that should not happen. So to quote, they say, to be clear, this forfeiture took place without any notice, before any adjudication had been made on the petitioner's case before the courts, and without merit, as the firearms were not involved in this or any other incident, states the petition. It goes on to note that Rupert was and is at all times a licensed firearm holder and a hunting permit holder. His firearms were safely stored. And it looks like he's seeking his stuff back, as well as costs, plus unspecified punitive, aggravated, and exemplary damages. So not only does he want his stuff back, but he wants them to pay for what they've done. And again, all of these are this is just the start of the lawsuit. We'll get more information later. This is probably going to be a long process, so there's not going to be any updates anytime soon. But the other thing I'll just note here is that if they were forfeited back in September of 2019, those guns probably don't exist anymore. They probably got chopped up in a chop saw, and his remedy is probably not going to be to get the actual guns back. It's probably going to be to get the value of the guns, which is unfortunate because I suspect most gun owners have guns that are of sentimental value. I've got a rifle that is, dear to me because it's the one I used on my first successful hunt. I've got a Cooey break action 20 gauge shotgun. It's worth approximately nothing because, a couple $100. It's not a valuable gun. But It's the only thing I have that belonged to my grandfather. So I don't want to lose that, not because it's some, $30,000 custom shotgun or anything like that, but because it's my only tie to, family members who actually never got to meet my grandfather. So it's literally the only thing I have of his other than sort of memories of seeing his pictures. I'd be very upset if that was chopped up by the RCMP, and especially I'd be very upset if that was chopped up without following the proper legal processes. Because as gun owners, sometimes all we've got in this system is the expectation of being treated fairly with the processes and procedures. And so if we don't even get to, enjoy the protections that are written into the law, how is that going to, how can we have confidence? How can we feel fairly treated by the system if we're not even getting those minimal protections? So the question is, how would they have seized this? And the news article, unfortunately, doesn't tell us how that forfeiture is said to have taken place, because that's a bit of a question. There's a few provisions that might cover this, and so let's go through some of the likely candidates just so that we can understand the law of how this might have happened. Now, the most likely way that this happens, and again, this is just a guess, is a seizure under section 117.04 sub 1 or 117.04 sub 2. Let's have a look at what those are. So these are sections that say where it is not desirable in the interests of safety of the person or of any other person. So that's both the person whose stuff they're taking or anyone else in existence, for that person to possess the weapon, prohibited device, ammunition, prohibited ammunition, or explosive substance. Either under section 1, they can apply for and potentially get a warrant to go in and search and seize those things, or under section sub 2, if there's some reason for a possible danger to safety of any person that prevents them from getting a warrant, they can go ahead and do so without a warrant. Now, if they go in with a warrant, they're required to provide a list to the justice of all the stuff they took. And if they go in without a warrant, they also have to provide to that justice why they went in and why they did so without a warrant. Like, why couldn't they wait? Once they do that, there's a provision that allows for them to apply to have those items disposed of. Now, that's under section 117.05 sub 1, and that notes that they must do so within 30 days. That puts our timeline about right, because we see August, September. So we've got a 30-day timeline. That sounds about right for the scenario here. They also allow for an ex parte hearing. Now, this is important because one of the guy's complaints is that they did so without notice. So let's look at, now an ex parte hearing means a hearing without one of the parties. So in theory, they can have a hearing without Mr. Rupert present. But there's provisions for that. There's rules, and he's entitled to the benefit of those rules. So a justice may proceed ex parte to hear and determine an application made under subsection 1 in the absence of the person from whom the thing or document was seized, in the same circumstances as those in which a summary conviction court may, under part, I'll go to that next, proceed with a trial in the absence of the defendant. Let's have a look at when that is. So, non-appearance of the defendant. If a defendant who is tried alone or together with others does not appear at the time and place appointed for the trial after having been notified of that time and place, or does not appear for the resumption of a trial that has been adjourned in accordance with subsection 1, the summary conviction court may proceed to ex parte to hear and determine the proceedings in the absence of the defendant as if they had appeared, or may, if it thinks fit, issue a warrant in Form 7 for the arrest of that defendant and adjourn the trial to await their appearance under the warrant. Now, note that that is after having been notified of that time and place. You can't use this section if there hasn't been notice. So because of that, and because this section is a requirement for 117.05, there's a requirement for notice. If there was no notice given, that's a big problem here. So if they were relying on 117.04 and 117.05, they're outside of what the law allows them to do here. And we see here as well, if on making the application, the justice finds that it's not desirable in the interest of safety of the person, then they can order those things to be forfeited and also issue a prohibition order. And that's another weird thing here, because the article says that he's still got a license, that he's still a licensed gun owner. And normally if a forfeiture order flows from 117.05, they'd ban him from having guns and he'd lose his license. So it's hard to tell if it's 117.04/117.05 that they're using here, or if it's some other procedure. But a number of things on this one line up, so it seems like the most likely scenario. But there's another scenario that we should consider here, and that is Section 490. And this applies to when they get a search warrant to go through and seize items, what can happen with that. Now here, this is essentially what this section says is, if you know who the person is, then you either have to, the person is who this stuff belongs to, then you either have to return that stuff to that person, or you have to satisfy a justice that the detention of these items are required for the purposes of an investigation or a preliminary inquiry, trial, or other proceeding. The easiest way to do that is charge somebody, and then you can say this is evidence in that trial. But it might also be necessary for an investigation. So as an example, if somebody is suspected of some sort of computer crime, and you go through and you're pretty sure that they've done it, you've got all sorts of evidence, you get a warrant to go in and seize his computers, it's going to take some time to go through all those computers and figure out, what evidence do we have? Is there actually something going on there? Especially, if you think about some sort of complicated financial crime, sorting that out is going to take a while. It's not going to be something, simple and easy. So then they'd have to go and tell the justice, here is why we need it for an investigation, and the justice will give them some time for that. Now, when they get that, they get 3 months unless they make an application for more time, which they're probably going to get, assuming that they haven't been sort of screwing around. But if an accused is ordered to stand trial, then that provides for it to be held until the trial is basically dealt with. So all of this kind of makes some sense, but kind of doesn't make much sense. On a peace bond application, it's not clear that they'd need to hold this as an exhibit, but maybe, so it might be under subsection 4. However, this section also requires that there be notice. They can't just say, we see subsection 5, that there's a provision that says if it's no longer required, then the prosecutor or peace officer, etc., shall apply. And it notes who shall, after affording the person from whom the thing was seized or the person who claims to be the lawful owner thereof or person entitled to its possession, if known, and in this case clearly they knew because they took it from him, an opportunity to establish that he is lawfully entitled to the possession thereof, make an order. So he's got to have notice, and he's got to have a chance to come in and say, I'm entitled to have this stuff back. So this section also requires notice, and I'm not aware of a section that would allow them to keep his guns without notice. But ultimately, we don't have all the information yet. All we've got is a news report about a lawsuit that's been filed. So maybe more will come out about this, but at first blush, what it appears is that they took his stuff without properly affording him due process. And if that's the case, then I hope that the Crown will look at this and say, we screwed up, let's give him his stuff back. But I don't know. I suspect that there will have been some negotiation and discussion with the RCMP before this, because usually filing a lawsuit is kind of the last step, not the first step. So I suspect that he's been sort of repeatedly asking and saying, can I have my stuff back? And they've almost certainly been saying, no, you can't. It's our stuff now. So you can't have it back because we get to keep it. So yeah, that's a bit of a headache. I don't know how to untangle this one, because it would be nice if there was some provision of the criminal code or some other act that I was aware of that said, yeah, they can do this. Here's why they did it. Here's why Mr. Rupert is wrong. Here's why he loses. But I don't see that. It looks from, assuming that we take Mr. Rupert's claims as true, and they haven't been proven, it's entirely possible maybe he did get notice. Maybe he just ignored it. Maybe he didn't notice that he'd gotten notice. But assuming his claims are accurate, it seems like he's got a good case. But so that's kind of where that shakes out. That's my reaction to this one. I can't be certain about any of this because it's early on in the process. All of these are sort of unproven claims, but unless some more information comes out that suggests that that something happened that is contrary to what seems to have been reported, I think he should win. But we'll see. I'll try to follow up on this one. It might be a little difficult to do, but I'll try to see and keep tabs on what's happening in court. It's an interesting scenario in any event. So thank you for watching. I hope you found this to be interesting or educational. If you have, please like, share, and subscribe. It's really important. It helps the channel grow. I really do appreciate it. I want to thank everyone who's watching. In particular, a special thank you to $50 supporter George, $30 supporter Steve Browning, as well as $10 supporters Ma Buddy Keith, Process Eng, Stephen Larson, Mark D, General Counsel of the CCFR, John Robinson, Tim Rogers, Roy Haddock, Fracklesdack, Jean-Alexandre Tessier, Cameron Johnson, Sir Goat, Sights and Arms Limited, Chaba Hollow, Peter H., Craig Kwan, Akin Coxall, North Central Process Service, Toys Are for Boys, Ian Vaughn, Milan Vrekic, Terrence Griffiths, Doug Thompson, Malcolm Taylor, Brad Crooker, Jason Harrington, Lee Kiso, Mark Stout, Scott Sweetman, Mike Rhodes, Alvaro Batarier, DF, Stacey Cartmel, TATV Canada, I think that's Tactical Advantage TV Canada. Check them out on YouTube as well. Ian S. Once again, thank you for watching, and hopefully this has armed you with knowledge.